Got to tell them that they're ready.
Court rise. Appeals in the matter of Spear and Stormsure Ltd and the Secretary of State for International Trade and Minister for Women and Equality. Parts heard.
My Lord, Mr. Milson would like to address you on something briefly, and I'm very happy for him to do
Yes,
that.
of course.
Yes, my Lord. It's just a quick point on when the Article 14 discrimination crystallises. And the point of no return, we say, on proper analysis is perhaps not the introduction of the Equality Act 2010, but the introduction of the vicarious liability provisions into the ERA as regards whistleblowing in 2013. Because it's at that point that the dismissed whistleblower can pursue claims against co-workers, can pursue claims with a lower threshold of proof, and benefit from injury to feelings. And the genesis of the ERA provisions is obviously dealt with by the Court of Appeal in Osipov, tab 46.
Yes, but
Paragraphs 28 to
the change
33.
in 2013 was the introduction of, let's call it, accessory liability in
Yes.
shorthand. But the interim relief remedy in whistleblowing had been available from the start, hadn't it?
That's right.
That Public Interest Disclosure Act.
That's right. And of course, the 2010 Act was the opportunity to change that.
Yes.
But when it comes to points of comparison, etc., and the increasing route towards whistleblowing being regarded as an anti-discrimination tort, we say that the introduction of the vicarious liability provisions in 2013 is a significant moment in that. Now, of course, victims of discrimination have never been able to obtain interim relief. From the inception of the whistleblowing provisions, whistleblowers were able to. So that much is obvious in common ground. But in terms of the comparison becoming more difficult to rebut, if I put it that way, the introduction of the vicarious liability provisions in 2013 is an important step.
Why? It doesn't change, I think, I haven't looked this up, you slightly taken me by surprise, but the 2013 made it easier to pursue the individual tortfeasor, manager, co-worker, whoever it is. But it didn't change the nature of the remedy against the employer, did it?
It did.
It did.
In this sense, at that point, for the reasons that are explored in Osipov, you can pursue a dismissal claim against your employer, vicariously liable for the acts of its employees or agents, and you have the twofold benefit of a lower burden of proof, not sole or principal reason, but more than a trivial part, because it's dismissal as a detriment, and you also benefit from injury to feelings. And that's the effect of Osipov. Whilst Osipov is ostensibly concerned with individuals, the Court of Appeal went on to say, and indeed this was the concern expressed by by counsel for the employees involved, that it drives a coach and horses through section 103A, because it lowers the burden of proof and it facilitates access to injury to feelings. But the effect of Osipov is the ability to sue the employer for dismissal, dismissal procured by the actions of employees, agents, those for whom the employer is vicariously liable, with the benefit of a lower burden of proof and access to injury to feelings.
Compensation for injury to feelings.
Compensation for injury to feelings, yes.
All right. Thank you very much, Mr. Milson. We're going to ask Mr. Purchase when he gets to the right point in the argument to make submissions about Elisabeth, and then you can always reply. Thank you very much.
Lord, my lady, I'm moving on to the question of status now in the Article 14 analysis. It's obvious but important for me to start by saying that there are two aspects to the status question. The first is whether the status relied on is in fact a prohibited ground within the meaning of Article 14. But the second is whether the alleged discrimination was in fact done on that ground. It's not enough for a claimant to say, I have a protected status. She must also show that the discrimination was done on the ground of that protected status. Turning to the first status on which this appellant relies, it is the fact that she had brought, excuse me, discrimination proceedings in the employment tribunal rather than any other sort of proceedings. My submission on that point is straightforward, and it is that this court, with respect, is bound by the House of Lords decision in the Hooper case to hold that bringing legal proceedings does not count as a status for the purposes of Article 14. The Hooper judgment is behind tab 19 in the bundle. And it is a case which concerned access to widows and widowers' pensions. But the point which is relevant for present purposes is dealt with by Lord Hoffman at paragraph 64 at page 409. And the complaint he's addressing there is a complaint that the government was willing to make payments by way of settlement to widowers who had petitioned the Strasbourg court before the Human Rights Act came into force, but was not willing to make payments to individuals who had petitioned the court after that date, or who had not petitioned the court at all. And in paragraph 65, Lord Hoffman, giving the leading judgment, said, in my opinion, there is nothing in this complaint. The argument fails for a number of reasons. The first question is whether discrimination by reference to whether or not someone has started legal proceedings is covered by Article 14 at all. In R.S. against Chief Constable of the South Yorkshire Police, Lord Laing, with the agreement on this point of the other members of the House, said that Article 14 required discrimination to be by reference to some status analogous with those expressly mentioned, such as sex, race or colour. See also the Kielsen case. Being a person who has started legal proceedings does not readily appear to qualify as a status. Now, in my submission, read in context, that is plainly an operative part of Lord Hoffman's reasons for rejecting that complaint. It is one of a number of reasons which he said led to the failure of the argument, and indeed it is the first one that he identifies. That being so, in my submission, the fact that, as I accept, there has been some development since that date in the approach to working out what is and isn't a status for Article 14 purposes, does not, with respect, entitle this court to go behind that decision. There has been no overruling of the Hooper decision by the House of Lords or the Supreme Court. In fact, the Hooper decision was raised and discussed recently by the Supreme Court in the Stott case. And although Lady Black pointed out that one cannot any longer push the analogous with the existing grounds argument too far, no doubt was cast on the correctness of the actual decision.
Just before we move on, have a look at the paragraph 80 at tab 51.
Indeed. Could I ask you to start, if I may, at paragraph 47 before I move to tab 80? And paragraph 47 is where Lady Black refers to the Hooper case and specifically 3 lines up from the bottom notes that he considered whether being a person who has started legal proceedings qualified as a status and was not persuaded that it did. In explaining why he appeared to adopt and develop Lord Stein's analogous approach, which he described as being that Article 14 required discrimination to be by reference to some status analogous with those expressly mentioned, such as sex, race, or colour. And then moving to paragraph 80, and of course there has been quite a lot of discussion in between. But what Lady Black says there is that as to the argument that the characteristic needs to be analogous to those listed in Article 14, this is difficult to pursue too far in light of the ECHR's acceptance that a prison sentence of a particular length can be within the article. But I have no difficulty in accepting that when considering an as yet unconsidered characteristic, a court will have in mind the nature of the grounds it was thought right to list specifically, that the case law that the court cited in Clift demonstrates that a strict justum generis interpretation would be unduly restrictive. And in my submission, what that does not do is undermine the conclusion reached by Lord Hoffman in the Hooper case, and it certainly does not overrule it. If, in my respectful submission, Lord Hoffman's conclusion was wrong, that is a decision which can only be made by the Supreme Court. In the meantime, this court, I would respectfully submit, is bound by it. May I just make 1 or 2 other points on that particular issue? The first is that my learned friend referred you to Mr. Justice Cavanagh's own decision in the Leighton case, where he held that bringing legal proceedings in a certain jurisdiction did amount to a status. The Hooper judgment was not cited to Mr. Justice Cavanagh in the Leighton case, at least not so far as I can tell, having read through the judgment. And just one additional short point, which is this, that although I accept that a relatively broad approach to status should be taken, it must be intended to add something to the question of discrimination. There must be some cases where there is a distinction which does not amount to a status for Article 14 purposes. And the fact that some judges have felt able to express the view that that is likely to be in a minority of cases doesn't tell you very much about whether this is one of those cases or not. There are examples in the authorities of cases where different legal regimes applying have been held, both by the European Court and the domestic courts, not to amount to a status. They're not on all fours precisely with this situation, but in my submission, I'll take you to them in a moment, they do reinforce what I say about the Hooper case still being authoritative, at least as things stand. The first one is in fact in the Stott case itself. So we're still behind tab 51 and paragraph 41. Lady Black refers there to the case of Minter against the United Kingdom. Mr. Minter was sentenced to an extended sentence for sexual offences. But if he had been sentenced later under a different legislative regime which then applied, he would not have received an extended sentence and therefore would not have been subject to additional requirements attached to it. He submitted that was an unjustified difference in treatment based on other status. And the court's decision on that is in the quoted section in paragraph 43. And just below letter A on the following page, 1239. In the present case, the different treatment complained of did not concern the length of the applicant's sentence, but rather the different sentencing regime applied to him as a consequence of new legislation. As a result, his complaint is indistinguishable from that which was declared inadmissible as manifestly ill-founded in Massey. Although Massey predated Clifford and so on, the court reaffirmed that no discrimination was disclosed by the selection of a particular date for the commencement of a new legislative regime. Now, obviously, I don't argue that this case is on all fours with that. We are talking about legislative regimes which exist at the same time here. But it does suggest a certain reticence in my submission, even in Strasbourg, to find that the application of different legislative regimes as being a sufficient ground for discrimination for Article 14 purposes.
Minter's quite recent. Strasbourg case, they're still using the phrase only differences in treatment based on an identifiable characteristic or status. So you say being a litigant in type of case A as opposed to B is not an identifiable characteristic or status.
I do say that, my lord, but as I say, my primary submission is I don't really even need to argue that point because I simply say that Lord Hoffman has dealt with it and there's no basis for this court to depart from. Before I move on to the argument that sex is the relevant ground here, may I make a few observations about whether it is even right to characterise the ground for the discrimination here as having brought a discrimination claim, because I don't in fact accept that is right. And the point I'm about to make is perhaps a relatively subtle one, but it is important in my submission properly to conceptualise what is actually going on here. This isn't a case where people who bring discrimination claims are being singled out for not having an entitlement to claim interim relief. There isn't a general right to interim relief which is subject to exclusions or conditions at all. This is a situation where nobody has a right to claim interim relief except that relatively narrow group of people who've been singled out to get it. And therefore, in my submission, the right conceptualisation of the basis for the distinction is that the claimant is not relying and has not brought one of the claims in which interim relief is available. Now, it may be that that makes no particular difference to the argument on status, but in my submission, it is important to grip that that is the reality here. It's not because she's brought a discrimination claim in particular that there's a problem. Moving on then to the question of sex being the relevant ground, I of course accept that sex is a status which falls within the scope of Article 14. What I say is that it is not on any arguable basis the ground for the difference in treatment here. It is important again, excuse me, to start by appreciating that the discrimination with which this court is concerned is not the allegedly discriminatory dismissal, which forms the basis of the claim. It is the difference of treatment in terms of the availability of interim relief. It is that which the claimant must satisfy you was done on the ground that she was a woman. And in my respectful submission, it plainly was not. Both men and women can claim interim relief if they bring a claim in which it is available. Both men and women cannot claim interim relief if they bring only a claim in which it is not available. That means that the only argument available to the claimant is an indirect discrimination sort of argument, where a general measure is said to disproportionately prejudice women. That, I accept, falls within the scope of Article 14. We know that from the Grand Chamber case in DH, which is cited in Burnip. And can I just take you to that, because I think it's worth just looking at what the test actually is. It's tab 31 in the authority bundle, paragraph 11.
Was this the Roma case? DH? It was Roma.
It was indeed, my lord, that's right, yes. We haven't actually produced the full report of that case for you, but simply I think because it is already here. But what the court said in that case, paragraph 11, is that Article 14 embraces a form of discrimination akin to indirect discrimination in domestic law. So just pausing there, it's worth noting that the court accepts that there is a kindred nature between the domestic indirect discrimination and this form of discrimination. And the approach under DH at the bottom of that page is that a general policy or measure that has disproportionately prejudicial effects on a particular group may be considered discriminatory, notwithstanding that it is not specifically aimed at that group. And I say that in deciding whether a general measure has a disproportionately adverse effect on people with a particular characteristic, you have to look at the impact of that measure on everybody to whom that measure applies. And I'd like to attempt to make good on that point by taking you first to the ESOP case in the Supreme Court. That's behind tab 38. And this concerned two joined appeals. The first one, ESSA, concerned civil servants, and what was discovered was that a particular test for promotion disadvantaged people of certain ethnic minority statuses because they were less likely to be able to meet it. The second case was a case concerning Muslim prison chaplains who earned on average less than their Christian counterparts, and the reason for that was that they hadn't actually been employed at all for quite a long time in the past, and so they had less time to climb up the ladder, so to speak. And one of the questions was, well, who do you need to compare to work out whether indirect discrimination exists? And at paragraph 21 and 22, Baroness Hale sets out the European definition of indirect discrimination, that's the EU definition, and then the existing UK definition. So we can see at paragraph 21, just below letter D, that the EU law definition is that indirect discrimination shall be taken to occur when an apparently neutral provision, criterion or practice would put persons of a racial or ethnic origin at a particular disadvantage compared with other persons, unless that PCP is objectively justified. So in my submission, materially the same approach as set out in the DH case for Article 14 purposes. And then at paragraph 22, Lady Hale set out an example of the way that is transposed into the domestic legislation. And again, I would submit materially the same. Lady Hale then spent some time considering the nature of indirect discrimination. And then at paragraph 41, she addressed the question of how the comparison needs to be made, which is known colloquially as the pool, to be applied. And what she says is, consistently with observations set out above, the statutory code of practice prepared by the Equality and Human Rights Commission advises that in general, the pool should consist of the group which the provision, criterion or practice affects or would affect, either positively or negatively, while excluding workers who are not affected by it, either positively or negatively. In other words, Lady Hale says, all the workers affected by the PCP in question should be considered. Then the comparison can be made between the impact of the PCP on the group with a relevant protected characteristic and its impact on the group without it. That makes sense, she says. It also matches the language of section 19(2)(b). And then a little further down, there is no warrant for including only some of the persons affected by the PCP for comparison purposes. And it is clear in my submission that there are two reasons in that paragraph why Lady Hale takes that view. The first is, as she puts it, it makes sense. It is simply what is, as a matter of common sense, required for an indirect discrimination analysis. But it also matches the language of the particular provisions which she was considering. And that takes me, if I may, to the unison litigation. You were referred to the Supreme Court judgment yesterday, but can I take you first to the Court of Appeal judgment, which is behind tab 36? The unison case, of course, was about the introduction of employment tribunal fees, whereby legislation was introduced which split tribunal claims into two categories, type A and type B. And the way the legislation worked was that it specified a number of claims which were type A, and then provided that every other sort of claim was type B. As my learned friend noted yesterday, unfair dismissal claims and discrimination claims fell into type B. So did a lot of other sorts of claims. In fact, all whistleblowing claims fell into type B. Collective consultation claims fell into type B. Part-time workers' claims fell into type B, as did a failure to inform and consult on a transfer of an undertaking, and so on. The point I'm making is that it's not just discrimination and unfair dismissal claims which fell into that category, but both of them did. An argument was run on behalf of Unison in that case that it would be legitimate in testing whether the higher fee for type B claims was indirectly discriminatory to narrow the type B claim pool only to people who brought discrimination claims. And that was a useful thing to do because more women than men brought discrimination claims. And that was addressed by the Court of Appeal, starting at paragraph 97. And what the Court of Appeal does is describe that as variant 2 of the indirect discrimination argument and refer first to Lord Justice Elias's judgment in the Divisional Court below.
Sorry, we're on the Court of Appeal, not the Supreme Court.
We're on the Court of Appeal.
Which tab?
It's tab 36.
Yes, right. Sorry, which para?
97. And 97 sets out the way that the case is put, and I do want, if I may, to spend some time on 98, which is where Lord Justice Elias addresses the point. And his view was that I do not think that to select a subgroup of cases within category B is a legitimate way to seek to establish indirect discrimination. It is necessary to test any potentially adverse effect of the provision criterion or practice by focusing on all those who are subject to it, and the overall pool to whom the PCP is applied. It is not legitimate to take a self-selected group. That simply distorts the true effect of the PCP. Moreover, it yields bizarre results. If there is an adverse impact on women for discrimination claims, there must be a corresponding adverse impact on men for all non-discrimination claims. And apparently there is for unfair dismissal cases, for example. Miss Monaghan's riposte is to say that there may well be indirect discrimination against men in those cases, and that this would need to be justified too. But on that analysis, even if the PCP operated to advantage one sex overall, by a judicious selection of a particular subgroup where the claimants were predominantly of the other sex, it could be shown that the rule indirectly disadvantaged the group predominantly advantaged by the PCP as a whole. By choosing a subgroup which is in practice predominantly of one sex, say nurses or building workers, or selecting claims typically made by one sex rather than the other, as has been done here, it would be possible to show that there was in fact indirect discrimination being practiced in a whole variety of ways, and each distinct type would have to be justified. I do not accept that the concept of indirect discrimination has such unacceptable and arbitrary consequences. In paragraph 99, Lord Justice Underhill then summarised what Lord Justice Elias had said, and at paragraph 100, Lord Justice Underhill said, in my view, that is right. Further down paragraph 100, as I've already made clear, the different formulation now in use has not entailed any change in the essential ingredients of an indirect discrimination claim. And then at the bottom of paragraph 101, 5 lines up, women are no doubt inherently more likely than men to bring sex discrimination claims, but the requirement to pay type B fees is not applied only to sex discrimination claims, or indeed to discrimination claims generally. Now that point went up to the Supreme Court in the passage that Learned Friend referred you to yesterday. That judgment is behind tab 52. And at paragraph 125 of that judgment. Lady Hale identified there the two ways that the case was being put. Firstly, that one compares all type B claims against all type A claims, and in fact you do find that there is a disproportion in the number of men and women bringing those types of claims. It's a relatively small one, but there is one. And Lady Hale says, well, that's enough to give rise to prima facie discrimination, looking at everybody who was affected by the PCP. Then at 132, Lady Hale looks at the alternative way that this discrimination case is put. The charging higher fees for discrimination claims is indirectly discriminatory against women who bring the majority of such claims and others with protected characteristics who also bring them. As my learned friend said, Lady Hale noted that there's a superficial attraction to that argument, but went on to express why that superficial attraction doesn't carry through. At paragraph 133, she referred back to the Divisional Court and Court of Appeals approach to it. And then at paragraph 134, she says, it is not necessary finally to resolve this question in these proceedings, but I am inclined to accept this is correct.
Which paragraph have you just read from?
134.
134.
Oh, yes.
Yes, 134.
Yes.
And so, in my submission, what my learned friend needs to satisfy you of is that those claimants who are not able to claim interim relief are significantly more likely to be female than those claimants who are able to claim interim relief. And the fact is that there is simply no evidence whatsoever which could establish that proposition. And just to make the point clear, the statistics that were used in unison simply tell you nothing about the relevant proportions of people bringing interim relief type claims and non-interim relief type claims, because those two types of categories are not coincident with type A and type B claims. They are completely different.
I think we can work out from general knowledge of life, as well as Lord Justice Elias's Divisional Court judgment in unison, that the overwhelming majority of sex discrimination claimants are men. Women, sorry. I'm sure it's more than 90%. I don't know what the figure is. I don't think we have it in. There will be other sorts of litigation which are broadly gender neutral. I would guess, for example, that roughly half of road traffic accident injured claimants are men and half are women. The same may be true of whistleblowers. We have no evidence to the contrary. But it's Mr. Milson can think about this before he replies, but it seems to me to be painting with a very broad brush to say that there is some form of discrimination of Article 14 taken with some substantive article, to say that because the terms of business for, say, road traffic claimants are in some respects more favourable than for sex discrimination claimants, that somehow means that for sex discrimination claimants, overwhelmingly women, are the victims of discrimination because, say, personal injury claimants can get interim payments and or legal aid or cost shifting or whatever it may be, and sex discrimination claimants can't.
My lord, what I say is that we know from Unison that that is not a legitimate approach to indirect discrimination claims. You can't pull out a subgroup of those who are disadvantaged by the regime, which happens to have more women in it. You have to look at everybody who's disadvantaged by the regime. And in this case, that includes not just sex discrimination claimants, not just discrimination claimants, but also unfair dismissal claimants, and indeed anybody else who's not within the scope of the interim regime provisions. And as you say, my lord, it's not just that we don't have the data to establish that side of the balancing act. We don't have the data to establish the other side either. It's entirely possible that more women than men also bring whistleblowing complaints. It's simply not a case in my submission where the material that's before this court entitles it to find that the relevant disproportionate effect on women exists in this case. So my lords, those are, and lady, those are my submissions on status.
Yes.
I'm moving on now to the question of analogous situation. I think it's probably fair to say that there'll be a certain elision of my submissions between the next three grounds that I'm going to deal with. But firstly, I accept from the authorities, of course, that in some cases it can be more convenient to put off the analogous situation question to the justification analysis. In my submission, there are potentially two reasons for that. The first is that the justification analysis may in effect decide the analogous situation question because you'll be relying on the differences in circumstances as part of the justification argument. It may be that if the court were to find that the discrepancy was justified anyway, there's no need to consider the analogous situation question. But what I do say is this, is that however one approaches it, it is not possible to avoid the fact that being in an analogous situation is a necessary aspect of making out an Article 4 discrimination claim. One way or another, it has to be addressed, or else the claim fails on other grounds. And of course, cases do succeed and have succeeded solely on the basis that particular claimants are not in analogous situations. What then is the correct approach to considering whether individuals are in an analogous situation, in particular whereas here what we are looking at is a context in which they are subject to different statutory regimes? That has been addressed by the Supreme Court in the Stott case, and if I could take you back to that, please, at tab 51. The case concerned different sentencing regimes applicable to various categories of offenders who had committed serious offences. And for certain offences, an offender would get what was called an extended determinate sentence. That would be a custodial term and then a short extended licence period. Other people, often committing offences which were just as serious, might get discretionary life sentences, and those would have a minimum term under which they would be imprisoned, and then they would be under licence for the rest of their life. And what the claimant, Mr. Stott, complained about was one aspect of those regimes, namely when you could get released on parole. And under the extended determinate sentence regime, you could only be eligible for release on parole after you'd served 2/3 of your sentence, or rather 2/3 of your specified term. But under the discretionary life sentence regime, you would be eligible for parole after you'd served half of your minimum specified term. And what the court says is, well, you cannot isolate that particular feature of the claim in deciding whether those individuals are in an analogous situation. You have to look at the two regimes holistically. It was a majority decision. Lady Black, Lord Carnworth and Lord Hodge were the majority. And I'll start, if I may, with Lady Black's judgment, and in particular at paragraph 153. And just pausing there before I delve into it, what Lady Black is dealing with at 153 is the justification question. The way that she ended up approaching it was to look at justification first, but then also to make a decision on an analogous situation afterwards. And that's why I'm taking you in, as it were, in the justification starting point. And at 153, Lady Black says, questions that are more difficult before the prisoner is eligible to apply, the parole board is an appropriate means of achieving the aims and whether it is disproportionate in its impact. She refers to the margin of appreciation allowed to the contracting state and points out in the last sentence, this court must equally respect the policy choices of Parliament in relation to sentencing. At 154, in the end, the answer depends significantly, I think, upon whether one concentrates entirely upon the early release provisions or looks up from the detail to consider the various sentencing regimes as complete regimes. Ultimately, I am persuaded that the proper way to look at the issue is by considering each sentence as a whole, as the Secretary of State invites us to do. And then moving on to 155, in between letters E and F, she points out that there are counterbalancing features across both regimes. But in other ways, some things are more favourable under the one regime, some things are more favourable under the other regime. And she goes on to say this fundamentally undermines the argument that the difference in treatment between the two prisoners in relation to early release is disproportionate, or putting it more plainly, unfair. I would accept that on the whole, bearing in mind the EDS sentencing package as a whole, the early release provisions are justified as a proportionate means of achieving the government's legitimate aim. Thus, although I would accept that Mr. Stott has been treated differently on the grounds of other status within Article 14, there being objective justification for the difference in treatment of EDS prisoners, his claim must fail. It's not in fact necessary in those circumstances to give a definitive answer as to whether EDS prisoners can be said to be in an analogous situation to other prisoners. However, there is a significant overlap between the considerations that are relevant to issue 2A, that's the analogous situation issue, and issue 2B, that's the justification issue. And having looked at those matters again in the context of issue 2B and considered the complete picture with the benefit also of what Lord Hodge has to say on the subject in his judgment, I've come to the view that EDS prisoners cannot be said to be in an analogous situation to other prisoners. Most influential in this conclusion is that, as I see it, rather than focusing entirely upon the early release provisions, the various sentencing regimes have to be viewed as whole entities, each with its own particular different mix of ingredients designed for a particular set of circumstances. And just briefly, can I take you to what Lord Carnworth and what Lord Hodge say about it, which is essentially the same thing. The difference is that they both treat it, as it were, as an isolated preliminary point, rather than Lady Black, who looked at justification and then came back to it. But in Lord Carnwath's judgment 180, in particular, I agree that the EDS regime must be looked at as a whole and cannot be treated as analogous to regimes which have different purposes and different characteristics. It's wrong to isolate the particular feature of the provisions for release on parole and compare it with other release provisions without regard to their context. And then Lord Hodge at 193, when assessing whether Mr. Stott is in an analogous situation to other prisoners, it is important to have regard to the reality that in England and Wales there are separate sentencing regimes which have different characteristics. It is appropriate to take a holistic approach to each sentencing regime in deciding whether or not one regime is analogous to another. My lady and my lords, I say that this is clearly a case which ought to fail on analogous situation grounds as well as on justification grounds. And I have two essential reasons for that submission. The first is that, as I submitted yesterday, the claims which do attract the right to seek interim relief share particular and important characteristics. They are all claims which concern actions taken by individuals in a collective or public interest, or in a representative capacity, or in joining a trade union for the purposes of engaging in collective pursuits. I have in my skeleton argument in an appendix set out the claims which do attract interim relief. There are a fair number of them, but they do, in my submission, all have those characteristics in common. Discrimination claims, on the other hand, and indeed all of the other claims which do not attract interim relief in dismissal circumstances, have a different quality. Now, I wish to be clear, again, that it's no part of the Secretary of State's case that discrimination claims are less important in a general sense. That is not what's being argued. What I'm saying is that they are different in their conceptual nature, looking at the basis for the distinction which is being drawn in these two cases. Discrimination claims are about asserting and vindicating individual rights. They're important individual rights, but they are individual rights. So that's my first point. My second point is that when you take the holistic approach mandated by Stott, the regimes looked at overall are different. My learned friend is right, of course, to say that since the Court of Appeal's decision in Timis and Ossipov, an employee who is dismissed on the ground of having made a protected disclosure has available to him or herself two options. They can make a claim for unfair dismissal under Part 10 of the Employment Rights Act, or they can make a claim for detriment on protected disclosure grounds under Part 5 of the Employment Rights Act. And I accept what my learned friend said was the consequence of the Timis and Ossipov decision, which is that your detriment claim is formally about the conduct of the individual who dismissed you. rather than your employer, but that the employer can be vicariously liable through that regime, so that the employer can have liability under both parts of the 1996 Act. That is true, but in my submission, it really does not have the significant consequences that my learned friend contends for. And there are two reasons, I say, for that. The first is this. I accept that in making your decision, you must have regard to that wider availability of relief under the Employment Rights Act. But it remains the case that an employee can only get interim relief through the Part 10 route. You cannot get interim relief through making a claim for whistleblowing detriment. And therefore, in order to get interim relief, you still have to meet the particular requirements which attach to unfair dismissal claims.
You can't get interim relief against actions which don't amount to dismissal.
That's right.
Because the nature of the interim relief spelt out in sections 128, 129 is to say that the contract continues.
Indeed. But there are other consequences of that. For example, you would need to bring yourself within the other particular restrictions which amount to a requirement in Part 10, and one of those relates, let's say, to the burden of proof. So if you don't have 2 years' service,
yeah,
you can bring a detriment claim which amounts to dismissal with no problem. You can't get interim relief for that. If, on the other hand, you want to get interim relief, you're going to have to persuade the tribunal that you can prove that you were dismissed on that ground, and you have the higher burden of proof in doing it.
Yeah.
And the second point, and this is perhaps more important, but certainly important, is that even if you were to ignore all of that and you were to look at Part 10 and Part 5 completely as a whole regime, there remain a lot of significant differences between that regime on the one hand and the Equality Act regime on the other hand. And once again, as in Stott, some of those favour the discrimination claimants, some of them favour the whistleblowing claimants. So moving on to identify some of those distinctions, if I may, could I ask you to look at my skeleton argument at paragraph 9?
Yes.
My first point of paragraph 9.1 is the difference in the range of claimants to which the different regimes apply. And that remains, in my submission, the case. It is true, of course, that a detriment claim can in theory be brought by a so-called limby worker as well as an employee, narrowly defined. But claims under the Equality Act can be brought by a much wider range of individuals than that. They can be brought by agency workers, they can be brought by public office holders, they can be brought by private office holders, they can be brought by pupil barristers. There is a much wider range of individuals who can bring claims under the Equality Act than can bring claims even under the extended whistleblowing regime in the 1996 Act. And potentially one answer to that is that, oh yes, but we're only talking about employees because only employees can claim interim relief. And to that I say two things. The first is that's not enough to enable you to ignore the wider context in looking at whether these are analogous situations. But the second is that that in itself is an important point of distinction between the two regimes, because the Equality Act does not draw a distinction between employees narrowly defined and the wider category of workers. Every worker is entitled to the same rights and the same remedies under the Equality Act workplace provisions. That is not so under the Employment Rights Act 1996. And indeed, the very fact that the detriment regime and the dismissal regime are contained in different parts of that Act and have different provisions applying to them makes that point particularly forcefully in my submission. My second point at 9.2 is the range of causes of action. And I do want to spend a little time on this because in my submission this is actually a very significant difference between the two regimes. The claim which can be brought under the 1996 Act, whether it is a dismissal claim or a detriment claim, is a claim that you have been dismissed on the ground or for the reason that, depending on which section you look at, you made a protected disclosure.
Well, your first bullet point in 9.2, claimant may be brought only, claim under 1A3A may be brought only where the claimant is dismissed or subject to detriment.
Yes. And my lord and my lady, if you would like me to take you to these statutory provisions, I am happy to do
Not
so.
particularly.
The only reason I'm not is
set this out very well.
the time.
Yeah.
Yes, so it's put slightly differently. So the way it's put in section 103A is the reason or principal reason has to be that they made a protected disclosure. The way it's put in the detriment provisions is on the ground that they made a protected disclosure. But the range of claims available to discrimination claimants under the Equality Act, all of which may apply to dismissals, is vastly wider. And I've set them out in the second bullet point there. It can be a so-called direct discrimination claim where the claimant is dismissed because she had a protected characteristic. But it's important to note that direct discrimination claims may also be brought not on the ground that you actually had the protected characteristic, but that somebody else had the protected characteristic. You can't bring a whistleblowing detriment claim on the ground that somebody else made a protected disclosure. It can also be brought on the ground that your employer believed that you had a protected characteristic, even if you didn't. Again, that doesn't apply to whistleblowing claims. You have to have actually done the protected disclosure. Moreover, there is a concept of indirect discrimination, which is wholly different to anything contained in the Employment Rights Act. You have to be dismissed in such cases pursuant to a PCP which places persons at a particular characteristic at a particular disadvantage. In fact, we've discussed that a moment ago. There's also a concept of harassment, where the protected characteristic doesn't have to be the reason for the dismissal, but if the dismissal is related to it, and you can say that the dismissal caused or contributed to the creation of an adverse or hostile environment, you can bring a harassment claim. There's also victimisation claims, and perhaps it is the victimisation claims which are most juridically similar to the whistleblowing detriment claims. But again, they're wider because you can be dismissed on the ground that the employer believed that you had done a protected act for the whistleblowing, for the victimisation provisions, or indeed that the employer believed that you might do a protected act for the purposes of the whistleblowing provisions. And then finally, there are particular discrimination categories applicable to persons with disabilities, so-called discrimination arising from disability, where again, the reason doesn't need to be the disability itself. It simply needs to be something which arises in consequence of the disability. And the dismissal is disproportionate. And then finally, there's the well-known failure to make reasonable adjustments, and a dismissal, which is the result of a failure to make reasonable adjustments for disabled people, will also be discrimination. So if you were to parachute indirect discrimination into the Equality Act 2010, you have a choice. Either you have to say, well, it's not going to apply to all discrimination, it's only going to apply to a subcategory of it. Or you're going to be massively expanding the nature of the claims to which it applies. I'll skip over 9.3 and 9.4, although they are still relevant in my submission, in the sense that they apply to the Part 10 part of the regime, even if they don't apply in the same way to the Part 5 part. But 9.5 is also important. It's the time limits question. Both sorts of claims have a 3-month primary time limit, but a claim for whistleblowing dismissal, whether as a detriment or an unfair dismissal claim, can only be brought after that 3 months if it was not reasonably practicable to have brought it within the 3 months, and it was brought within a reasonable time thereafter. There is a much wider discretion to allow late claims in the Equality Act context. You can allow a late claim if it's just...
Does that matter in the context of interim relief? Because as Mr. Milson reminded us yesterday, to get interim relief, the claimant must make an application within 7 days of the date of termination.
It does matter, my lord, for this reason, I say, which is that, as the Supreme Court said in Stott, what you mustn't do is focus in solely on the particular feature which is said to be discriminatory in this case. In deciding whether those regimes put the individuals in an analogous position, you have to look at the whole context. And it has to be the case that if there are some things under the one regime which are more beneficial, that you take those into account, even if they are not connected directly with the alleged discriminatory provisions. Moving on to 9.6, and that's third-party liability. To some extent, that point is minimised by the fact that you can have third-party liability under the detriment provisions in the 1996 Act. But it remains the case that the scope for third-party liability under the Equality Act is wider, because the liability under Section 47B of the 1996 Act applies only to employees and agents, whereas the extended liability under the Equality Act, as I've set out there, also applies to any person who instructs, causes, induces, or knowingly helps the employer to commit discrimination. Such persons need not be, and fairly frequently aren't, employees or agents of the employer. Moving on now again, if I may, down to paragraph 9.9. This is another important distinction, which is that in an Equality Act claim, the Employment Tribunal has the power to make a recommendation that the employer take certain steps to address the problems which it has identified. And those are important, very important, to a lot of claimants. They often consider it particularly helpful and vindicative of their rights that their employer is told to do things which will prevent this sort of thing happening to somebody else, for example, or which will address the particular impact on them. They are only recommendations, but they are enforceable in the limited sense that if the employer doesn't comply with them, the tribunal can increase the compensation which it requires the employer to pay. But there's no scope for anything remotely similar to that under the whistleblowing regime. You will also recall yesterday that the availability of recommendations was something which was specifically addressed when developing the Equality Act regime, and a decision was made to expand the scope of the recommendations which employment tribunals could make. And then finally, at paragraph 9.10, we have interest. There's no power to award interest under the Employment Rights Act regime. There is a power to award interest on discrimination awards, which includes injury to feelings awards. Then there are, of course, a number of features which I accept are more beneficial if you look at it from the other direction. You can get a basic award, you can get reinstatement, and of course you can get interim relief if you bring a claim under the Employment Rights Act. Just finally, before I move on from this, the point I mentioned in paragraph 10, again, is not an insignificant point, and that is that Parliament has set up a particular statutory body which has the function, in part, of being able to assist claimants in discrimination claims, as indeed it is in this case. There is no equivalent body, no equivalent statutory body to assist whistleblowing claimants. So, my Lord, standing back from that, in my submission, we clearly have a situation here where, for the two broad reasons I've suggested, there is no analogy to be drawn between people who bring discrimination claims and people who bring whistleblowing claims. And in my submission, the fact that there is some similarity, both in terms of the underlying objectives of the legislation and in terms of the juridical structure of the particular causes of action, is not enough for these purposes to give rise to an analogous situation. My learned friend has, of course, drawn your attention to a number of judgments where the courts have drawn on discrimination concepts in interpreting the scope of the whistleblowing provisions of the Employment Rights Act 1996, and have said, I accept that there's a sufficient degree of similarity to make that appropriate. That does not change my submission, because it is important in my submission to recognise, firstly, the limitations of that overlap, which I've just dealt with. But secondly, the particular purposes of taking that approach in those particular cases. They have all been about whether you can use the discrimination understanding to inform your analysis of concepts which are essentially the same in the whistleblowing regime. And the answer to that is not unsurprisingly, yes, you can. So, for example, in deciding what the reason for a particular action is, a similar approach is taken to detriment under the 1996 Act as is taken to victimisation or direct discrimination under the 2010 Act. The Abbey National against Chagger case, which you weren't taken to but is in the learned friend Skeleton, was a case where the calculation of compensation was an issue. Again, not remotely surprising that the court would say, well, of course you take a similar approach. It's also been used to extend the scope of whistleblowing detriment to post-termination of employment detriments. Again, it's not surprising. If you can bring a post-termination claim for direct discrimination under the Equality Act, you'd expect to be able to bring the same in the similar context. Again, similarly, Timis and Ossipov itself is a very strong example of what the court is doing. It's saying what we have here is actually pretty much identical ideas in the two acts, and therefore we can use what we know from the Equality Act to inform what Parliament must have meant in using that same concept in the Employment Rights Act. But that is what all of those cases are about. They are about identifying what Parliament's intention was in using similar concepts in two different pieces of legislation. Even in that context, of course, you do need, I would respectfully admit, to exercise caution. And there is the very clear warning from Lord Justice Mummery in the Kuzel against Roche Products case, which is behind tab 26 in the authorities' fund law.
You quote the
I do.
paragraph, don't you, somewhere? I've lost it. It is just that, isn't it?
That's really the nub of it, my lord, yes.
Unfair dismissal and discrimination are different creatures. But, where is it?
It's paragraph 38 in my scale.
It's 48 of the judgment, I think.
That's right. So, my lord, what in a way that does is make much more effective the point that I was attempting to make just now. It's one thing to use discrimination legislation to illuminate what Parliament's intention must have been in using similar concepts. It's another thing to attempt cross-fertilisation or legal transplants between the two regimes. My lords, I'll move on now to the justification point. The general approach to justification in Article 14 cases is that set out most clearly in the Bank-Mellat case, which again you don't have, but is cited in Lawrence and Fenn Tigers, which you do have.
Yes.
That's, I'll just give you the note unless you need to look at it. It's tab 35, and it's set out in paragraphs 30 and 31. The first question is whether there are legitimate aims. I've set out what I say the legitimate aims are in my skeleton argument at paragraph 48, which reflects what is said by Mr. Ramsden in his witness statement. I will simply say that in my submission, all of those clearly are legitimate aims. My lord, if you are with me on that, what you are then essentially concerned with is whether the difference in treatment in question is a proportionate means of achieving those aims. And one important question which arises in that context is the degree of respect which you should accord to the decision made by Parliament to allow interim relief in certain cases and not in others. And it won't surprise you to hear that I submit that a very wide margin of discretion should be allowed in this context. If it is necessary to do so, I would say that the manifestly without reasonable foundation test does apply here. But whatever the position, a wide margin is called for in my submission. And can I just turn to one or two authorities on that point? The first is the Lawrence and Fenn Tigers case, which is behind tab 35. And in particular, paragraph 58. Lord Neuberger and Lord Dyson's judgment. And the second sentence there, even in a field such as access to justice and legal costs, while being vigilant to protect fundamental rights, the court, while being vigilant to protect fundamental rights, must give considerable weight to informed legislative choices, at least where state authorities are seeking to reconcile the competing interests of different groups in society. In such cases, they are bound to have to draw a line somewhere in order to mark where a particular interest prevails and another one yields, making a reasonable assessment of where to draw the line, especially if that assessment involves balancing conflicting interests, falls within the state-wide discretionary area of judgment.
Well, Mr. Milsom says, I'm parodying only slightly, this doesn't apply because nobody ever thought about it.
Yes, and I will. If you're content, I'll address you on that in a moment.
All right.
Just a couple of other legal propositions before I do that, if I may. Firstly, could I take you to the Court of Appeal's judgment in the Joint Council for the Welfare of Immigrants case, behind tab 49. And in particular, starting at paragraph 127. Of Lord Justice Higginbotham's judgment, and what his lordship is dealing with here is the manifestly without reasonable justification test for justification. And what he says is the test of whether the adverse effects of a measure are manifestly without reasonable foundation derives from the European Court of Human Rights in the context of assessments by a national legislature as to what is in the public interest when implementing or applying EU law. And then over at paragraph 133 little 4. Lord Justice Higginbotham says that welfare benefits, of course, comprise an area of policy in which both economic and social considerations feature very large. However, there is no apparent logic or rationale for restricting the social economic policy areas in which Parliament and the Executive, as democratically responsible bodies, are uniquely qualified to assess the public interest as against other interests, to those of welfare benefits. And I say that this is a context in which the social, political, and economic interests are such as to call for such a sensitive balancing act that the manifestly without reasonable justification test should apply.
Well, since the JCWI case, there's been Drexler, in which I sat with Lord Justice Singh about a year ago, and he said one shouldn't get too hung up about manifestly without reasonable foundation. If the test is you must give a great deal of respect to the choice of the democratically elected Parliament on matters of social policy, that's not that different. And the question is whether either of them applies to the present case, but there was a great deal of learning on when NWRF did apply and when it didn't. And it seemed to me that Lord Justice Singh was saying, don't worry about it too much.
Yes, my lord, I am certainly not submitting that it's going to make a significant difference to your decision in this case. I don't think I'm in a position to accept that it might not make a significant difference in other cases. But certainly for my purposes today, it's not likely to matter a great deal. Just briefly on what my learned friend said about the Gillam case, where Lady Hale addressed whether the manifest without reasonable justification test applied. that was paragraph 34 of her judgment behind tab 44. But all I really want to say about it is that Baroness Hale does not say that the manifestly without reasonable foundation test cannot apply in the employment context. What she says is that it has not always been applied in the employment context. In fact, that is exactly what she says. The implication being that sometimes it can be applied in the employment context. And in fact, an example of that, although one which I accept is very different from the present case, is the Independent Workers of Great Britain against Treasury case that my Lord Justice Bean sat in recently concerning the job retention scheme, which essentially was a process by which the government made payments to protect employment.
Adiatu. I was in Independent Workers of Great Britain, but it was a different.
Oh, I'm so sorry. I may have got those mixed up. But yes, that's the case I have in mind.
I see that.
But they were both. I'm so sorry, Maud. Adiatu and WGB were both claimants in that case, apparently, which is where my confusion came from, according to the report, anyway.
I see that Lord Justice Hickenbottom went on in the passage that followed the ones that you cited to consider Drexler, because it had been handed down following the hearing, but before the judgment in this case, and to reach the conclusion, which is rather much in line with what you're submitting, that on the facts of the given case it may not make a great difference. But I think that his view was that it turned, and I'm looking at paragraph 139 to 141, on the degree to which economic and or social policy are involved in the measure in question. That should dictate, or at least guide, the degree of deference that the court shows. So it's very much specific to the nature of the particular case that's being considered.
Yes, my Lord, I don't dissent from that, although I would submit that that's not the only question relevant to the degree of deference which should be accorded. And that takes me on to identify, I hope relatively quickly, three particular features of this case which, whatever the legal test, I say should lead this court to be particularly cautious about second-guessing the position. The first is the source of the different treatment here. The source, of course, is decisions made by Parliament. It is right that there is no evidence of specific contemporaneous consideration of this particular narrow point in the context of the whole regime. But in my respectful submission, Parliament must be taken to have been aware of what it was doing. There are a number of reasons for that, both constitutional and based in the real world. The first one is that the interim relief provisions were introduced for the first time in the Employment Protection Act 1975. That is in the exact same parliamentary session that the Sex Discrimination Act 1975 was introduced. And more than that, the Employment Protection Act in section 77 specifically refers to the remedies available in the Sex Discrimination Act. You'll find that in tab 3 of the authority. And section 77 is on page 8 at the bottom of the page. And we can see that that deals explicitly where compensation falls to be awarded in respect of any act, both under the Sex Discrimination Act 1975 and under the provisions of this act relating to unfair dismissal, and makes provision in relation to that. the very next section, section 78, is the section which confers the right to claim interim relief only in a limited number of unfair dismissal cases. My lady and my lords, I set out in my skeleton argument in the footnote on page 9, page 56 in the bundle, the fact that since that point, what has happened is that discrimination legislation has been extended, reinforced, reenacted over a long period of time. And during exactly the same period, the right to claim interim relief has been extended to a number of other areas. And that being so in my submission, it simply is not, in my respectful submission, the case where you can say that Parliament was somehow unaware that it was extending interim relief only to certain categories and not to other categories. And the reason for that is clear. It's the one I've given, which is that Parliament has clearly chosen to limit interim relief to a certain type of claim. It cannot possibly be a coincidence that all of the claims in which you can claim interim relief are of the sort which I identified earlier, and the ones in which you can't are not. And in those circumstances, in my respectful submission, it would be constitutionally inappropriate to proceed on the basis that Parliament did not know exactly what it was doing in making those decisions. Another point is that while I accept there is no direct evidence of precisely what Parliament was thinking on this particular very specific issue, there is very clear evidence of a very detailed consideration of what the Equality Act 2010 should look like and how it should balance the various competing rights and interests of those involved in it, and what remedies should be available and extended. And that followed, of course, a very detailed consultation period.
And is there any evidence that anyone in the consultation period suggested that interim relief should be extended to these claims? Presumably not.
No, Malaysia doesn't. Two further points. The first is that as Lord Justice Leggett, as he then was, said in the C case to which you were taken yesterday, the mere fact that this is an Act of Parliament means that it is deserving of a degree of respect. And my final point is that the issue has now been expressly considered by the Executive. And you can see details of that consideration in the witness statement of Mr. Ramsden, particularly paragraphs 15 to 17. Now, I accept, of course, that consideration after the event will generally carry less weight than consideration before the measure in question is taken. But I would say two things. The first is that Mr. Ramsden's account, in my submission, plainly reflects what the reality was throughout this period. And secondly, even if that is not the case, his approach is still deserving of a degree of respect. My second point for according a wide margin of discretion is the context of the treatment in question. I'll deal with this briefly because I've dealt with it before. These are detailed, nuanced and complex schemes. They necessarily strike a number of balances. This isn't a case where it's even just one balance to be struck. One has to strike the balance between the private interests of claimants and the private interests of respondents, between the private interests of particular individuals who can take up tribunal time by claiming interim relief, and the interests of other litigants in the employment tribunal whose cases will be delayed. You have to balance the private interests of claimants against the public interest in limiting public expenditure and indeed on the impact on the economy of what are potentially high impact on individual employers. It is, in my submission, very much a socio-political evaluation, as Mr. Justice Cavanagh accepted in his judgment. My third point is the difficulties inherent in drawing the line in a particular place and the consequences and potential consequences of drawing it in a different place. This is not a case where it is being suggested to this court that interim relief should be generally available in the employment tribunal. What is being said is that it needs to be available in discrimination claims as well as the claims which you have in front of you. That being so, a line has to be drawn somewhere. And the place to draw that line is, in my submission, plainly, properly a matter for the elected Parliament. There is a real difficulty in my submission in drawing the line anywhere else. The first reason for that is that it will undermine the rationale which I have put forward for having interim relief at all. If you're to extend interim relief to discrimination cases, how on earth do you then not extend it to other cases? Unless your position is simply that we think discrimination cases are really important and therefore deserve special treatment.
Well, more important than other types of case such as unfair dismissal.
Precisely, but that, my lord, is a problematic approach. I'm not saying it's right or wrong, but what I am saying is that is by definition a policy judgment, and it's a judgment therefore which needs to be made not by the courts with respect, but by those arms of the state which are responsible for policy. The second problem is, well, if you are to extend it to discrimination generally, do you cover all the different types of discrimination? Because it may also be a genuine and fair policy assessment to suggest that some forms of discrimination are more serious than others and more deserving of particular protection. Dealing, if I may, with then the practical consequences and in fact the legal consequences if you were to extend the regime into the discrimination provision.
But I think you set them out very well in your skeleton, and I've been debating some of them with Mr. Milson. Insofar as you've set it out in your skeleton, then I don't think you need to spell out the problems.
My lord, I will in that case move over my first 2 points, which is the impact on the balance between the two statutory regimes and the impact on the Equality Act itself, which on any analysis is going to be significant because you're going to have to split something out of what is at the moment an entirely coherent workplace regime. But one point that I do want to raise, which is significant, it is a point that my lord raised earlier, but there is a concern, a real concern, that there is a risk that moving the line will in fact create discrimination rather than resolve it, and will certainly create the risk of other claims of discrimination. A point that the court raised yesterday is, what about workers? At the moment, workers and employees are treated exactly the same throughout the Equality Act. Why shouldn't workers have the right to continuation of their contract if their contract is terminated for dismissal grounds? Similarly, what about office holders? Should it extend to them? But the risk of discrimination also comes in the other direction. It comes from the whistleblowers themselves. If you are to adjust the balance between the two regimes by saying that people who claim of discrimination should have the right to claim interim relief, why shouldn't a whistleblower say, well, why shouldn't I be entitled to the more preferential time limits regime to which the discrimination claimant is entitled to. Why shouldn't I be entitled to ask the tribunal for a recommendation? And that is the problem, essentially, in drawing out particular narrow aspects of regimes and parachuting them in. It works in both directions, and deciding on the balance of that is important. The third point, which I hope I can deal with relatively briefly, is the practical impact. I just want to expand on what I've said in my skeleton argument on that a little, by reference to the statistics. There will undoubtedly be more hearings if discrimination claimants can claim interim relief. At present, the data suggests that there are about 119 applications per year on average. There are, or rather there were, in 2019 and 20, 2,827 protected disclosure-based claims. I did, my lords, make large A3 copies of the statistics for you. And my lady, I'm sorry. Unfortunately, my technical wizardry was not as good as I'd hoped. It's actually cut out the protected disclosure column. But what my learned friend and I have suggested is that we agree a table of all the relevant statistics.
Could you
send
as long as
that.
you've both seen it, could you send it in
Indeed.
large format
Yes.
afterwards?
So we have 2,827 whistleblowing claims, and that includes detriment and dismissal whistleblowing claims. There were 23,777 discrimination claims, again including
23,
including dismissal.
7 what?
23,777.
Is Mr. Milsom right to say that the volume of discrimination claims has dropped sharply over the last few years? I don't know that it makes a difference to the judgment in this case, but I would like to know.
I confess I don't know that for sure. I certainly know it dropped as a result of the fees regime.
Oh yes.
I confess my understanding is that it's been increasing since that had been removed, but I'm certainly not in a position to suggest otherwise at the moment. But the fact remains that last year there were 23,777.
Yeah.
That doesn't include equal pay claims. And of course, sometimes claimants will resign and claim constructive dismissal on the basis of a failure to pay equal pay, so they will add potentially something. But even limiting it to the 23,777, if you were to assume the same rate, you'd have more than 1,000 additional applications in any given year. And as the court suggested yesterday, and I would respectfully agree, in probability it's going to be more than that. And that's for two reasons. The first is that it is likely to be easier to fit your claim into a discrimination jacket in order to bring a claim for interim relief than it is to fit it into a whistleblowing jacket. Because to bring a claim for whistleblowing, you have to show that you made a protected disclosure. And the second reason is that extending the regime into discrimination will make it much better known, and therefore make it more likely that people will bring claims.
Mr. Milsom says that the high standard of proof is a really significant brake on the number of, at least the number of successful interim relief applications. Would you say that?
I certainly accept that most interim relief applications are not successful. But people do bring them, and I'm basing my submissions at the moment on what the actual data shows. As I mentioned in my skeleton, of course, it is important that the consequences in this case are not just the consequences to employers of having to pay, it's the consequences to the system of having to have the hearing in the first place, and indeed to the employer of having to attend.
Well, to me, it's a bit puzzling that if the rate of success is so low, they keep on coming. It doesn't seem like a normal market behaviour. But are you suggesting that if the extension took place, there would be a different approach? I think your assumption is that the sort of rate of claims would be the same.
I am. That is my assumption. One of the difficulties is that, of course, one just can't know for sure what is likely to happen.
Do we know what the success rate is? You said that 119 interim relief cases a year or thereabouts, but we don't know how many of those succeed.
I don't have that at my fingertips, but I can try and check. I am aware that it's a very low proportion.
Is it? Right.
But of course, as my lord said, it's quite difficult to really assess what impacts the mere threat of interim relief has on cases in some circumstances.
It would be interesting to know if you can find out. My guess is that the great majority of the 119 would be whistleblowing rather than the trade union linked ones, and that the trade union linked ones, though rarer, would be more likely to succeed. But if there is reliable information as to whether that's so, then...
My lord, I'm afraid I do know the answer to that question,
Right.
and that is that we don't have that information.
Yes. Well, the document I gave you yesterday, which was the annotation to the Employment Protection Consolidation Act 1978, which I still have, it has an interesting narrative of the very early years of this provision, when it was trade union activity only, and there was a tiny number of claims, but more up-to-date information, if it existed, would be helpful. But if it doesn't exist, too bad.
Sadly, it doesn't. Attempts have been made, my lord, but we have not been able to.
I suppose it cuts both ways, doesn't it? I mean, if there's a very low success rate, it's not much of an advantage to the sex discrimination claimants to have it.
Well, that is true, because you do have to weigh the extent to which this is really a problem, particularly in a case like this, where of course the claimant could have sought interim relief on the basis of a whistleblowing claim.
Well, she did, didn't she? Didn't she withdraw her application?
Two short further points, if I may, on the justification, and then I'll deal very briefly with remedy. The first is that there was a brief discussion about the complexities of discrimination. It was suggested, well, that's not terribly different from whistleblowing. Two answers to that. The first is that it's not, even if they are similar in complexity, the fact that you've got so many additional complex claims to deal with is itself a problem. But the second is, I would submit that discrimination claims certainly are very often more complicated than whistleblowing claims. Finally, there is the effect on, if I can put it this way, litigation conduct. What having an interim relief regime does, of course, is encourage a rush to litigation. You have to bring a claim within 7 days of the termination of your employment. That means the wheels start turning. And of course, it is important government policy at the moment that employees and employers should be strongly encouraged to resolve their disputes without resort to litigation, hence the early conciliation regime, which is in force, and to which, of course, interim relief claims do not apply. So there is no obligation to contact ACAS for the purposes of early conciliation if you bring a claim for interim relief. For obvious reasons, there's not enough time. But that is important. And that the impacts on settlement are in my submission, significant. There is a real risk that interim relief applications will impede the likely fairness of any settlement for two reasons. The first is, if the claimant succeeds, any sensible employer is going to pay more money than they otherwise would have paid, because the claimant is going to be continually paid until the final hearing, which may be a long time away. But the reverse is also true. Many claimants are likely to be seriously adversely affected by losing an interim relief application, and therefore potentially more likely to settle for lower sums of money. Another point is that if claimants succeed in interim relief applications, they're very unlikely to take any steps to mitigate their loss. Why would they? They've got a guaranteed income until such time as the final hearing. And indeed, in truth, that guaranteed income may result in them getting more, in effect, by way of damages than they would have got or if they hadn't been granted the interim relief and had taken reasonable steps to find alternative employment. So, my lady, my lord, standing back, whatever test you apply in my submission, this is a justified regime. Finally, I move on to remedy. And I hope to be able to deal with this briefly, but there are one or two legal propositions that I would like to take you to. There are, of course, limits to the Section 3 interpretative obligation. And just dealing briefly with a point that arose yesterday, Parliament clearly has reserved to itself the right to do things which are not compatible with the Convention. And indeed, the Section 6 obligation on public bodies to act compatibly with Convention rights does not apply to Parliament. That's express provision in Section 6.3. My learned friend took you to the Coleman case, which contains a useful summary of the position. There's one particular passage I would like to draw your attention to, which he didn't take me to. It's tab 30. And it's at page 653. It's easier to use the page because it's a very long paragraph. And what we have here is excerpts from Lord Nichols's judgment in Guyton against Mendoza, and paragraph 32 of the quoted excerpt, Lord Nichols says at letter C, Section 3 goes further than this, enabling language to be interpreted restrictively or expansively. It is also apt to require a court to read in words which change the meaning of the enacted legislation so as to make it convention compliant. So that he is clearly treating as an extreme consequence of Section 3. Just pausing there in my submission, it is one thing to say you can read in words which change the meaning of legislation. That is an act of interpretation, albeit an extreme one. It is another thing entirely to parachute into an act a completely different form of remedy, which is not in the act at all, which cannot possibly be treated as changing the meaning of the legislation. It is simply introducing something which is brand new. Paragraph 33 is then important. Parliament cannot have intended that in the discharge of this extended interpretative function, the court should adopt a meaning inconsistent with a fundamental feature of the legislation. That would be to cross the constitutional boundary. Section 3 seeks to demarcate and preserve. Parliament has retained the right to enact legislation in terms which are not convention compliant. The meaning imported by the application of Section 3 must be compatible with the underlying thrust of the legislation being construed. Words implied must, in the phrase of my noble and learned friend Lord Roger Aylesbury, go with the grain of the legislation. Nor can Parliament have intended that Section 3 should require courts to make decisions for which they are not equipped. There may be several ways of making a provision convention compliant, and the choice may involve issues calling for legislative deliberation. And a similar, but not quite the same point, was made in the Court of Appeal in a case which is cited in Rostock against Giussemi behind tab 33. paragraph 41. And Lord Justice Underhill is there citing Sir Andrew Moritz, the Chancellor's judgment in the Vodafone case. And in the second quotation, Sir Andrew sets out constraints on the broad and far-reaching nature of the interpretive obligation, and it's letter B just below, sorry, it's small b just below letter G on the side. One constraint is that the exercise of the interpretative obligation cannot require the courts to make decisions for which they are not equipped, or give rise to important practical repercussions which the court is not equipped to evaluate. So my learned friend scoffed a little yesterday at the fact that in my skeleton argument I accept that it simply isn't possible to know what's going to happen if this change is made. But that is precisely something in my submission which should count very strongly against this court taking the Section 2 approach. That being the law, my four very short reasons for saying you should not, therefore, adopt a compatible reading in this case are these. The first is one I've mentioned. It's one thing to extend the scope of an existing right. It's quite another to introduce a brand new remedy into a sophisticated and elaborate scheme. In my submission, on no analysis can that be treated as a matter of interpretation, even on a Section 3 basis. The second is that I do submit that the balance and the boundaries of the remedies and procedures available under the Equality Act is a fundamental feature of the scheme. The Equality Act is, of course, designed to advance equality rights and to enable claimants to enforce them. But as is clear from the legislative material which I took you to yesterday, its purpose is also to do that in a way which is proportionate and balances the various rights involved. The third point is that you are being asked to make a decision which, with the greatest of respect, you are not equipped as a court to make. To put it in the terms of the Court of Appeal in Ben Carbush against Sudan, you would be interfering with the balance struck by Parliament without having Parliament's panoramic vision of the landscape. As I mentioned earlier, it's not just the balance of interests within the Equality Act, but the relationship between these two regimes and questions about how far you should go if you decide to open the door a little bit further. These are all policy decisions which ought to be for Parliament. And my final point is that it is difficult, if not impossible, properly to assess the practical repercussions of doing that in this case, and in particular the impact on other litigants. But one distinct paradox of the claimant's position is that it's part of her case that this is a particular problem for her, because there are delays in getting claims finally determined in the Employment Tribunal. But the more interim relief applications there are, the longer those delays are going to be. My Lords, I hope you'll forgive me for concluding by reading what I've said in the conclusion of my skeleton argument. It's my submission that this claim, this appeal, falls to be found against the claimant effectively at every stage of the analysis. That, in my submission, is not surprising in this context. What we are talking about here is a very complicated and finely balanced system of employment law which has been carefully developed over time. We've focused only on two particular aspects of it, but of course those take their place in a much, much wider context. There are numerous causes of action, each of which address particular issues and concerns, and each of which have their own carefully calibrated legislative schemes of enforcement and remedy. It is my submission that Article 14 is just not apt or intended to be used as a tool for reading across piecemeal particular remedies available in one regime into a different regime. This will unbalance the overall system in ways which are very difficult to anticipate on a case-by-case basis. And if there is to be any attempt to regularise the law across the different existing regimes, in my respectful submission, that must be a matter for Parliament. My Lords and my Lady, unless there's anything further I can assist you with, those are my submissions.
Thank you very much, Mr. Purchase. Mr. McHugh.
Thank you, my Lords, my Lady. Before I start with my submissions in full, I'd just like to formally, on behalf of the respondent, echo the appellant's gratitude towards Mr. Justice Cavanagh turning the judgment that he did around so quickly. It was the party were extremely grateful for the ability to produce a judgment of that calibre in such a short space of time. I'm conscious that this appeal has expanded somewhat in scope since the respondent submitted its skeleton argument in response.
Yes.
Our submissions are effectively confined to the issue of remedy and whether the purpose of construction sought by the appellant can be granted. I'm conscious that there will be some overlap with some of the submissions made just now by the Laing for the government in relation to the issue of justification and whether or not it was Parliament's intention to legislate in the way that they did. I'm also conscious of the time.
Yes, I mean, Mr. McHugh, you submitted the skeleton argument on the 15th of February. Since when Mr. Purchase has waded in with a big skeleton argument, and you've allowed him to, as it were, to lead you in sequence, so that there's no need to repeat anything he's said, but by all means point out anything he hasn't said.
Well, I'm very grateful. That was the point I was just about to make, is that I don't intend on. I'm grateful to Milan for doing most of the heavy lifting,
Yes.
and I don't intend to parrot the submissions that he's made. I'm more than happy to take an indication from you, Milan, that if an area has been sufficiently covered in detail, I don't intend to waste the court's time in relation to that. Broadly, what the respondent will submit is that the EAT was plainly correct to conclude as it did, that it was not able to read into the Equality Act the construction sought by the appellant. I will focus on two broad areas in my submission. First, the intention of Parliament. Secondly, the panoramic view question, namely whether the court is equipped to assess the practical repercussions of an amendment of this that we said expected to be. Dealing then with the intention of Parliament, the EAT's judgment and reasoning on the intention of Parliament is set out at paragraphs 143 to 146. That's at page 262 of the core bundle for your note. At paragraph 45 of the skeleton submitted on behalf of the appellant, and again for your notes, that's at page 36 in the core bundle. The submission is made essentially that there was no basis for the EAT to reach the conclusion that they did, that Parliament deliberately intended to legislate in the way that it had. If you read the detailed consideration set out by Mr. Justice Cavanagh in that judgment, in my submission, it's simply not a sustainable contention to say that there was no basis for the EAT coming to the conclusion that they did, given the level of analysis of the history of the legislation and particular passage of the Equality Act that Mr. Justice Cavanagh carried out. I'd make three short further points in relation to intention. Firstly, as we've already heard at some length, Parliament has been carefully considering and revising discrimination legislation for a period of almost 50 years now. The remedies for discrimination throughout that period have been fairly consistent. Claimants who have been unfairly dismissed on discriminatory grounds have been entitled to a declaration, in certain circumstances a recommendation, and compensation. At no point throughout that period have successful claimants who've been the victim of discriminatory dismissals been able to enjoy any sort of mandatory right, like reinstatement or re-engagement, unless that has been brought alongside, unless the discrimination claim has been brought alongside an unfair dismissal claim. The appellant's contention yesterday, with reliance on the report at tab 73 in the authorities bundle, again that's for your reference, I don't propose that we return to it, is that the appellant's contention that the UK is an outlier in relation to remedies for discriminatory dismissals and cites other countries that provide nullities or mandatory reinstatement orders. In my submission, somewhat undermines the suggestion that Parliament has not turned its mind to the question carefully of what remedies ought to be available in discrimination claims. I submit that it cannot be right, similarly to what my learned friend submitted shortly ago, that just because there's no express reference to whether or not interim relief was considered to be part of the Equality Act or not, doesn't mean Parliament hasn't deliberately decided to legislate in the way that they have in providing remedies for those who are unlawfully dismissed by way of discrimination. In my submission, it's plain that there has been a deliberate and careful decision-making process followed in relation to what remedies ought to be available. And the fact that interim relief is not available, it, as my learned friend says, cannot be a coincidence. It's not something that's just slipped through. Secondly, in relation to this, I think it's relevant to consider the remedies that are specifically afforded to both the County Court and the Employment Tribunal, specifically in the Equality Act, at sections 119 and 124 respectively. For your note, that's at tab 8, page 105 and 108 in the authorities book. When considering what remedies ought to be available to those respective jurisdictions, Parliament deliberately decided to give the County Court all the powers that the High Court has when granting an injunction, when granting a remedy under judicial review, or any powers that the High Court has under any action for tort. But in relation to the Employment Tribunal, specifically doesn't afford the Employment Tribunal that benefit. Again, the Employment Tribunal's remedies are confined to declaration, recommendation and compensation. It must be that when considering the specific levels of remedy afforded to the County Court and the Employment Tribunal, that there was a consideration given to the level of remedy that was available to both, and that the deliberate decision was taken to retain effectively the non-mandatory remedies that the Employment Tribunal has of declaration, recommendation and compensation. My third and final point in relation to parliamentary intention, I place reliance on the remarks of Lord Justice Bingham in the case of EWP Moore, which is at tab 14 in the authorities bundle. Page is 222. I ask you to turn to that with a relatively short passage. I should start by noting that I am conscious that this relates to a rather niche
agricultural holdings.
The security anomaly. And the
I've never heard of
security
this
available
case.
to agricultural tenancies.
Show us what we need to see.
But it's page 228 in the it's 475 in the internal number, but 228 in the authorities bundle. And in addition to adopting the reasoning given by the rest of the court, what Lord Justice Bingham observed, and it starts at around where the letter B to C is, and that in relation to the issue with the agricultural tenancies, the attention of Parliament had been drawn to the apparent anomaly that agricultural business tenants had, and despite abundant opportunities, Parliament had not taken the opportunity to cure the anomaly, which cannot have escaped the attention of departmental lawyers and administrators. What Lord Justice Bingham goes on to say is that the inference, therefore, must be that either the anomaly is not considered to be an anomaly, or it is a desirable or tolerable one. And when considering the question of parliamentary intent in this case, I say that although it's a niche factual circumstance, those observations can have broader assistance in this case. Namely, has Parliament had an abundant amount of opportunity to cure the anomaly of interim relief not being available for the Quality Act cases? In my submission, clearly yes. Is this something that would have escaped or could easily have escaped the attention of departmental lawyers and administrators? No. And so in those circumstances, I say it's safe to infer that either Parliament doesn't see this as an anomaly, it sees it as a deliberate choice, or if it is an anomaly, it's a desirable one. Unless I can assist further on the issue of parliamentary intention, I'll move on to deal with the panoramic view question. I'll keep our submission on this point brief because, as I said, I don't wish the submission to be the conclusion drawn by the EAT in relation to practical implications is set out at paragraphs 149 to 150 of the judgment. For your notes, that's page 265 of the court bundle. What the EAT and what Justice Cavanagh went on to do was set out very detailed consideration of a number of policy concerns at paragraphs 151 to 158. We all know that's on page 265 to 268 of the court bundle. Whilst I don't propose we go through these in detail now, what I would say in short is that those concerns identified by the EAT were well considered valid, and they, to an extent, echo the submissions made just now by the friend of the government, which essentially amounts to the fact that discrimination legislation is a product of years of careful consideration and a balancing of competing interests. And with all due respect to both the EAT and this court, that must be making a substantial amendment to that legislation must be a job for Parliament. It would be, I say, an unenviable task for this court to undertake in attempting to assess the potential implications of widening the scope of interim relief to such an extent, and it's not one that I would propose this court should do. In summary, what the respondent says is this: the EAT was correct to reach the conclusions that it did in relation to relief, and the respondent would respectfully adopt the observation made yesterday, I think, by my Lord Justice Bean, in that this case it's essentially one of declaration of incompatibility or trust for the appellant. Unless I can assist you further, those are my submissions for the respondent.
Thank Thank you very much, Mr. McHugh. Very grateful to you.
My lord, I'm terribly sorry. May I beg your indulgence and ask to make one additional point, which I unforgivably overlooked? But
Yes,
has been
especially,
reminded of.
especially if it's a short one.
It's a very short
Yes.
one. It's to do with the point about reinstatement not being available in the tribunal. The first point about it is that the Secretary of State does not accept that the UK is an outlier in not providing for that. The paragraph that my learned friend took you to yesterday cites 10 different countries which provide reinstatement or something similar, or 11 if you include Belgium, which provides it in principle but doesn't in practice. That was of a survey of 33 different countries. So actually what the evidence suggests is that the UK is probably more typical than not. But the more important point is that what you are being asked to do in this case is allow the tribunal to grant interim relief of a kind which it does not have the power to grant final relief in. And that, in my submission, is a real problem, because there is no challenge before this court to the inability of the tribunal to grant final order requiring reinstatement or re-engagement. That's the
In a tribunal can never make an order for reinstatement or re-engagement which is specifically enforceable. The employer can ignore an additional penalty, but in unfair dismissal it's available, theoretically the primary remedy. If the dismissal is discriminatory, it's still available because it's a subspecies of unfair dismissal. Is that right?
My lord, no.
No, it isn't. Right. Okay.
But it has to be unfair and discriminatory.
Yeah.
Well, it has to be unfair, exactly.
Yes.
And of course, discriminatory dismissals may also be unfair
Of
dismissal.
course, there might be a case which was a discrimination case, but it has to be an unfair dismissal case.
Exactly.
But if somebody, as here, is saying I was dismissed or constructively dismissed, I haven't got 2 years service, so I either succeed under discrimination or not, reinstatement is not an available remedy.
In principle, the tribunal might recommend reinstatement,
Recommend.
but it couldn't make an order for reinstatement.
Yes, well, perhaps that's the next case. But anyway, I don't think we should worry too much about how many out of 33 member states provide various sorts of remedy.
I just wanted to make it clear that what my learned friend says about that is not accepted, just in case.
Thank you. Mr. Milson.
Yes, my lord. Just on the last point mentioned there first, the power to make recommendations has been used to address the reinstatement issue. There was a recent DAT case to that effect. And of course, we're dealing with situations where the reason for dismissal is discrimination. And that could never find a fair dismissal if the tribunal concludes that the reason for dismissal is a discriminatory one. Scope first. I've already taken my lady, my lords, to Joint Council of Welfare of Immigrants and what's said by on Ambit there, but it's important to reflect and reiterate that when it comes to the question of within the ambit of the substantive rights, particularly when we come first to Article 6 and the submissions of my learned friend on Article 6. Much reliance was placed upon Matthews and Roche. They were cases where the attempt to sue the Crown for negligence, and of course an essential ingredient of negligence is damage. A breach of duty in and of itself cannot find a claim for negligence. And so whilst there was certain references or citations of damages, it's damages contingent upon negligence. And the reason for that, on the face of the authorities of Matthews and Roche, is clear, which is that there was a specific legislative prohibition on pursuing a cause of action vis-à-vis the armed forces against the Crown. That's what those cases concern, and indeed there was a concession in Matthews that this was a question of substantive. But there's not that here. It's also been qualified somewhat by the cases of Z, UK and Osman, where the exemption for causes of action against the police and the local authority were found not just to be within the ambit of Article 6, but a substantive breach. Reference was made to Cahoe, and if I can take you to Cahoe, that's tab 62. The important point is that the court was considering Cahoe as a pure, is there a breach of Article 6? My learned friend seeks to rely upon it for the purposes of ambit. He cannot do so. Paragraph 31 of Cahoe makes clear, and I've attempted to find it without success, that there was an earlier admissibility decision. So the court had previously decided that there was admissibility of the claim. It couldn't have done so unless the claim was within the ambit of Article 6. So Cahoe is a decision on its merits as to whether there is a breach of Article 6, and the answer was that there was no bar on the right of the access to the court because there was access to judicial review, etc. Not that the claim was not within the material scope of Article 6 at all.
Mr. Milsom, I'm sorry, I should have mentioned this at the start of play rather than now, but I dimly recalled overnight and looked up this morning that there is a Strasbourg decision called APIS, APIS, in Slovakia in January 2000, in which they appear to have held that an application for an interim measure, I think what we would call an injunction, is simply not within Article 6. It's a page and a bit. The court finds the interlocutory proceedings complained of did not involve a determination of the applicant's company's civil rights or obligations within the meaning of Article 6, and then see also an unpublished decision in an Austrian case, 1991. And there is some learning on this in, or topic is referred to in some domestic cases, one of them involving Mr. Warby QC, although I haven't yet had a chance to read it, but it does suggest that article in the domestic case ABC Limited and Y, they refer to another Strasbourg decision, Micallef and Malta, Grand Chamber, 2009. Perhaps this is the one to look at because it is Grand Chamber. Preliminary proceedings like those concerned with the grant of an interim measure such as an injunction are not normally considered to determine civil rights and obligations and do not therefore normally fall within the protection of Article 6. And then it goes on to qualify that slightly in subsequent paragraphs. It may be that if you don't have Micallef and Malta at your fingertips, would you like to look at it in the next 24 hours? And if you want to make any submissions
Yes.
about it, send them to us, to my
Yes,
clerk,
certainly.
copy to Mr. Purchase. I'm not encouraging endless toing and froing, and I'm sorry that we
Not at all.
we come up against this at such a late stage. But the domestic decision is ABC Limited and Y. Mr. Justice Lewison, 2012, 1 Weekly Law Report 532, which, as I say, I haven't read it properly, but there does seem to be a degree of hostility in the Strasbourg jurisprudence to the idea that you can complain of a violation of Article 6 rights in the where what the court is considering is an interim measure rather than a judgment at trial.
That's addressing I haven't seen the authorities obviously, but if that's the issue that it's concerned with, or that the decisions are concerned with, that's an issue as to whether there's a civil right engaged.
Whether it's determined, Article 6 applies to decisions which determine, in the determination of civil rights, everyone's entitled to a fair trial,
yes,
and so on. But they seem to say determination means final. But anyway, I'll leave
the
that.
principal challenge, as I understand from the Secretary of State, is that the question of the right to interim relief or the access to interim relief is a question of substantive law.
Well, that's a different point.
Which is a different point.
Yes.
And that's where I was originally going. The point that's made in Matthews, perhaps worth turning up briefly, it's tab 17.
Yes.
And Lord Bingham, paragraph 4, starts a comprehensive summary of the development of the right to sue against the Crown and the specific exemption from doing so in respect of the armed forces. That's what Matthews and Roche are about. And that's contrasted at paragraph 18 with the case of Fogarty, where the immunity from pursuing a sex discrimination complaint on the grounds of national security was not only within the scope of Article 6, but amounted to a breach. And the reason being, if you look at D, that the applicant had an express statutory right to compensation for victimisation and discrimination under the Sex Discrimination Act 1975, right very closely aligned to that she had successfully exercised against the same employer. And a similar point is made in relation to the case of Tinelli by Lord Hoffman at paragraph 36. We say that the pre-existing substantive law right is the right not to be discriminated against, and that is the right contained in section 39. The real question is when that right can first be brought to the court, and that is a question of within the material scope of Article 6, and not excluded by reason of being a substantive law issue. Article 8, we agree with, or the claimant agrees with the real conclusion of Vining, which is that the mere fact of termination is not enough to engage Article 8. And that's the conclusion the court comes to tab 40, paragraph 47. But here, it is not the mere fact of termination, it's that the termination is imbued with a protected characteristic. Whether it's direct discrimination or failing to treat relevantly different cases differently, indirect reasonable adjustments, etc. There is a clear interplay between the protected characteristic and issue and the dismissal. And to the extent that my learned friend suggested that IB and Boyraz were decided on the basis of actual evidence of stigma, he is respectfully mistaken. For your conscious of time, so for your note IB tab 66 at paragraph 72, Boyraz tab 69 at paragraph 44, both speak in the language of assumption, because it's taken as assumed that where termination is on the grounds of a core status, of which all the Equality Act statuses are, then that is within the material scope of Article 8. There is a particular stigma that is attached because it goes to the heart of personal identity and personal autonomy. And Vining says no different. This doesn't address the issue at all. On A1P1, my little friend did not, in my submission, get to the heart of the matter, which is that the individual who is dismissed on discriminatory grounds has a legitimate expectation to wages, which is brought to an abrupt end by way of the dismissal. Likewise, there is a legitimate expectation of a cause of action, and the timeliness of that course of action and the enforceability problems that exist in the post hoc remedy regime identified by Unison are plainly within the scope of A1P1. On state,
I can't remember, Mr. Melson. Did you give us authority for the proposition that cases involving loss of employment, loss of wages are within A1P1?
they're dealt with in my written submissions, paragraph 13 and 14, page 176 to 177. O'Sullivan and McCarthy, restrictions on ability to pursue a business. Bramelid and Malmstrom, company shares. NKM, taxation on pay. Evelson, deduction from wages. And then Jurgis, to which I took you to, which is insurance benefits in relation to employment. But it's made clear across all of those that a legitimate expectation is enough. And I cite Savant Strabo holding in Ukraine at paragraph 14, and Zibek in Greece at tab 64, which is French translation only. But we say that a legitimate expectation, both as to a cause of action and as to wages, has already been recognised as within the scope of A1P1. On status, we are dealing with scenarios where something is done to an individual. They have either been expressly dismissed or they have been subject to such conduct that it fundamentally breaches their contract of employment, leaving an individual constructively dismissed. And they have to have lost their employment as a consequence of that, because the interim relief application is contingent upon dismissal. It is inextricably linked, because of the jurisdiction of the Equality Act, to one of a finite number of characteristics: race, sex, pregnancy, religion, belief, disability, sexual orientation, gender reassignment, or age, or a complaint about any one of those characteristics. They bring their claims because of something done to them. The correspondence to a protected characteristic is not accidental, it is the thing itself. And so it would be a surprising scenario in which this court respectfully concluded that the claimant had no valid status at all. Hooper is cited and put centre stage by the Secretary of State. The analysis of status in that case is confined to a single paragraph. And in the intervening 16 years, status has been considered on 4 occasions by the Supreme Court: AL, RJM, Matheson, and Stott. And in each of them, the departure from Hooper becomes clearer still. If I can take you to Stott, which is tab 30. Forgive me, tab 51. 47 identifies Hooper and really sets out the sum total of Hooper, or the reasoning in Hooper, which is that there had to be some analogous approach with those Article 14 statuses already identified. But as Lady Black concluded, the jurisprudence has evolved considerably, such that paragraph 80, as to the argument that the characteristic needs to be analogous, this is difficult to pursue too far in light of the European Court's acceptance that a prison sentence of a particular length can be within this article. And likewise, when it comes to Minter, on which my learned friend also places reliance, paragraph 78, just 2 paragraphs up. Question as to whether Minter really assisted at all, because given the conflating various issues of status analogous situation in the passage of Minter to which reference is made, it's difficult to be sure whether in fact the European Court was rejecting the other status argument or not. But in any event, the present case does not involve the commencement of a new sentencing regime. What's clear is that in Stevenson, in this court, tab 39, the timing of being an applicant for a social security payment was capable of being a status. The relevant status in issue is whether one was an applicant for disability benefit before or after a cut-off date of the 5th of January 2009, where a higher limit of loan and income support became available. So in other words, the status is, I was an applicant for a social security payment before the 5th of January 2009. And I took you in my submissions yesterday to paragraph 41. The majority of cases, it's now probably safe to say that the need to establish status as a separate requirement has diminished almost to vanishing point. Now, if the timing of making an application for a social security payment is capable of being a status, it would be rather difficult to see how being an individual who is pursuing a claim of disability discrimination or sex discrimination, as in here, would not be. Not least because the starting point is that it's something done to you as a disabled person, as somebody with a core status in the first instance. In other words, that there is already in existence a status which is identifiable in respect of that person. So at the very least, we say the EAT was right to conclude that there was a valid status. But of course, we go beyond that and identify the real status as being that of sex, because of course that is the reason why someone is dismissed, certainly why the claimant is dismissed. And the starting point, I think, here is that my letter from seeks to read across ESEP and domestic authority on indirect discrimination. As Baroness Hale pointed out in AL Serbia, that is an unsafe course. And there's no better illustration of that than Flemenos itself, in which the individual who, on grounds of their religion, refused to give military service could not obtain a role on that basis. And nonetheless was subject to Article 14 discrimination, notwithstanding the fact that there's no reasonable adjustments concept for religion, which would be the more natural domestic fit for this, notwithstanding the fact that the rule on having served military service applied across the board, and notwithstanding the fact there was no statistical evidence that it had a particularly heavy leaning on people of any particular religion or faith. And the reason for that, and for your note, paragraph 39 of the Melos tab 60, is that the European Court has consistently recognised that there are certain categories of status which require more favourable treatment. That the individual of a particular religion requires to be treated more favourably. That in some cases, different situations require more favourable treatment. And that's across the...
Why does that help here?
Well, because we say that the suggestion that the real comparison is with ordinary unfair dismissal, or that the disadvantage is not because of bringing a discrimination claim, but because one is not in the category of cases where interim relief applies, doesn't really grasp the nettle. What Article 14 requires is recognition that there are certain categories of case which have to be treated differently and more favourably. And repeatedly, domestic courts have identified the characteristics and the protected classes of the Equality Act as falling within that core group. Again, for your note, Carson tab 20, 55 to 57, Clift tab 23 at 51, AL tab 24, 27 to 30, RJM tab 29 at 5, Burnip tab 31 at 19 to 22, and C tab 41 at 61 to 65. A theme in Millennium Friends submissions on justification as well, although it perhaps may be more suited to the question of the Section 3 instruction, is that it's wrong to assume that Parliament has placed special value on discriminatory dismissals as opposed to ordinary unfair dismissals. But of course they have. There's no qualifying service period for an Equality Act dismissal. There's no statutory cap for a discriminatory dismissal. Parliament has already recognised repeatedly that a discriminatory dismissal is of a different nature.
You say that's not enough.
Well, we say that there is a valid comparison to be drawn, but with the dismissed whistleblower. Incrementally, whistleblowing has become an anti-discrimination tort. The problem crystallised with the introduction of the vicarious liability provisions, and Parliament has not since applied its mind to the question of whether the absence of interim relief, a very powerful remedy for reasons that Mr. Justice Cavanagh accepted and don't seem to be disputed before you, why that should not be extended to the individual dismissed on the grounds of sex, race, or disability. Another point that's been put by, when it comes to comparison, is that an individual is not, that the claimant and others like her are not discriminated against because of their sex, etc., but because they don't have, they're bringing a class of case which doesn't attract interim relief. And to an extent, of course, that's true. But it's the very analysis which the Supreme Court rejected in Gillam. In the Court of Appeal in Gillam, the Ministry of Justice said that it's not because District Judge Gillam is a judge that she can't bring whistleblowing claims, because she doesn't work under a contract, and that's the classification that the legislation draws. And that was accepted by the Court of Appeal, but overturned by the Supreme Court. Because what mattered critically is that her status, being a judge, led to her exclusion from the regime. In other words, don't focus upon causation, focus upon consequence. And on a similar theme, my learned friend is in danger of repeating the missteps which found favour with the Court of Appeal in Gillam, but were again rejected by the Supreme Court. One of the points he makes is that look at the other suite of goodies that the dismissed victim of discrimination may get. More generous time limits, the ability to pursue claims against individuals who induce, cause or instruct. Again, in Gillam, in the Court of Appeal, paragraph 39 of the Court of Appeal's judgment, points were made about the special recognition that judges have in terms of guarantee of tenure, guarantee of wages, etc., or stipends. But that didn't matter either, because the question is, in the enjoyment of this particular right, the right there to pursue claims of whistleblowing, the right here to seek a continuation of contract order or reinstatement, is there discrimination? And there clearly is. It is no answer
You
to...
say you're entitled in each case, as against the comparator, you're entitled to say, because this is call status, I'm entitled to a better deal on this one, on this one, on this one, on this one, on this one. And I may end up with a much better package, but that's a consequence of the fact that each of these comparisons must be made separately.
Well, the first question is the right in issue something of real value? And clearly it is.
Of course it is.
And it can't begin to be answered in my submission by matters which are ancillary to the real analysis of that particular issue. It is no answer to say to an individual who could bring their claim within 7 days of dismissal, well, don't worry, you can bring claims for causing, instructing or allowing by the way of a substantive hearing, or you could bring your claim outside the 3-month period. I'm bringing my application within 7 days. The application of a more generous extension of time provision doesn't assist. I'll take you, if I may, briefly to the passage in Gillam that deals with that. It's paragraph... tab first. Yes, it's tab 44. Firstly, paragraph 31. On the causation versus consequence point, which Claimant says should not be countenanced. Baroness Hale says this: it's no answer to say that by definition judicial office holders are not an analogous situation to employees and LIMB workers. That's to conclude that it confuse the difference in treatment with the ground or reason for it. What matters is that the judicial office holder has been treated less favourably than others in relation to the exercise of and enjoyment of the convention right in question. And then when it comes to comparing other benefits, paragraph 30, the point that the Supreme Court makes is that in respect of the enjoyment of that particular right, i.e. the right to pursue a whistleblowing complaint, she's denied the possibility of bringing those proceedings and the consequent advantages. It doesn't matter that there are additional benefits. What matters, particularly where the right is as material as this one, is whether there is differential enjoyment. And the other point, of course, that Gillam gets to is that there are clearly some differences in the status of a judge as any other LIMB worker or employee. But get to the heart of it, focus on the practical and effective enforcement of rights, and there is a clear difference in treatment. Just briefly, my learned friend suggested that there is a clear difference in relation to the belief in a protected act or a protected characteristic being covered, as opposed to an anticipated or suspected protected disclosure. There's a decision first instance only of Billsborough and Berry Marketing Services, which suggests that a suspected or anticipated protected disclosure is capable of being covered by reference to Article 10. My learned friend expanded upon his submissions in relation to doing something in the public interest. Again, we say that that is unsustainable. The doing something in the trade union membership case may be nothing more than having enrolled many months or years ago and simply paying wages automatically, paying union subs automatically, as opposed to the individual who raises or notifies their employer of their protected characteristic. But on the public interest issue, it's been recognised at the time of introducing the power to make recommendations that an individual who pursues a claim does so in a collective interest as well. In fact, that's the basis for the power to make recommendations. We can take you to tab 9, which are the explanatory notes to the Act. Page 112. Three bullet points from the bottom in relation to enables an employment section starting with enables an employment tribunal. Enables an employment tribunal to make a recommendation to a respondent who's lost a discrimination claim to take certain steps to remedy matters, not just for the benefit of the individual claimant, but also the wider workforce.
Yes.
And the whole point, of course, is that there is a recognised public good in combating discrimination. And certain changes made within the Equality Act recognise that. And of course, when it comes to justification, what the Secretary of State must establish is that the exclusion of all forms of discrimination from the benefit of interim relief goes no further than necessary. And it may well be that there are some guises of discrimination which engage public interest more than others. That may well ultimately lead you and your colleagues to conclude, my Lord, that the Section 3 exercise is a bridge too far. But it's important to consider separately status, comparison, justification, and not allow questions of disposal, the interpretive obligation, to muddy those waters. The line has to be drawn somewhere, point, is no answer to the fact that Parliament has at no stage considered whether the stark line which currently exists is capable of justification. On that, on the manifested without reasonable foundation point, Adiatu was relied upon. Of course, Adiatu was a case in which, in the midst of the pandemic, the government decided to extend the furlough scheme as swiftly and efficiently as it possibly could. That's a paradigm instance of the allocation of state resources in a time of emergency. I see no issue there with a manifested without reasonable foundation. It's a question of allocation of resources. This is not that. There is no sensible distinction that can be drawn between the Gillam scenario, category of classes benefiting from certain rights and remedies, and that here. Reference was also made by reference to, on the question of justification, to the deliberation that went into the Equality Act. And you were taken to the consultation paper at page 98 of the core bundle. On my count, there are 61 questions posed by that consultation paper. Not one concerned remedy. So it's fair to say that there is a whole suite of things that were considered. The present issue simply was not one of them.
Did they not ask a question about recommendations?
I don't believe they did. I may be mistaken. Certainly there's nothing on the question of the measure of compensation and still less on interim relief, because it was of course accepted by that stage that the purpose of any remedy is to put the individual in the situation that they would have been in but for the discrimination. That was well established by EU authority, the directive and marshal, but nothing on interim relief, of course.
Was there a free text box in the consultation?
Not that I could see. And the final point when it comes to justification I would seek to make is this. To the extent that it is legitimate for the Secretary of State to be concerned as to the administration of the tribunal system, in the sense that don't do this or we'll face a backlog, there are perhaps 2 points to make. Firstly, the Strasbourg Authority makes plain that it is for the signatory states to ensure that their systems of justice are convention compliant. And that should be less of an issue, given that the statistics show a drop of some 100,000 claims in the period from 2007 to now. But if the concern is that this would encourage hearings to drag on, etc., it's of note that as it stands, some 10% of sex discrimination cases that are issued, only 10% make their way to trial. And the question of whether the availability of interim relief would increase or decrease that, at the very least, goes both ways. The other point that the material put forward by the Secretary of State illustrate is that those cases where ACAS has no involvement at all are in fact less likely to proceed to a full hearing. These applications are rare. In my experience, I've had 4 in about 10 years, I would have thought. And the practice is the ability to get, in those rare cases, a trusted tribunal to gauge the merits of a claim either leads to resolution before the hearing is required or resolution very soon afterwards. The claimant, and through her the Commission, simply say this: Parliament has not applied its mind to this. It cannot justify the clear, absolute, no exceptions admitted bar on interim relief across discrimination claims. Nothing that has been put forward goes remotely close to establishing that that bar goes no further than necessary, given the significance of the rights in issue. And therefore it cannot be justified, whichever test of justification is adopted. You've heard from me on disposal. I'll say no more about it, unless I can assist further.
Thank you very much, Mr. Milson. Thanks to all of you. It's been a pleasure to listen to you. Very interesting case. You'll be less than astonished to hear that we'll reserve judgment. Now, the 2 loose ends are that between you, you'll give us the statistics in or the relevant ones anyway, in readable form, and I'm sure we sensible folk, you can agree what we should see. And Mr. Milsom, if you want to put in anything on the Apis and Slovakia, McAuliffe and Malta line of authority on whether Article 6 is engaged by this sort of case at all, then please do by sort of this time tomorrow. Would that be all right? Nothing lengthy is required. Thank you all very much.
Oh, well.